I tell all of my clients as soon as they naturalize, petition for your siblings. I don't care if they're 2 or they're 22. I don't care if they don't want to come to the United States. I don't care that your parents won't let them come to the United States because they're too young. Because guess what? By the time there's a visa available for your sibling, they're not going to be too young. And just to be clear, permanent residents cannot petition for their siblings. Only U.S. citizens can do that. So as soon as you can, file for the ones back home, because it's going to take a long time and a lot of things could change. So who's eligible? What constitutes a sibling? Well, obviously, if both your parents are the same, there you go. If you only have one parent who's the same, then you still count as siblings, you're half siblings. You can also petition for step siblings, but in that scenario, you have to be sure that the step relationship started before your sibling turned 18. So let's say your father had gotten divorced from your mother and married another woman. She already had a son, and so you now have a step sibling. As long as that son is under 18 by the time that marriage started, then it's all good. Whether or not you want to do that, I don't know, because your father could petition for that child. But there are a lot of scenarios where that might not play out. They might have only lived together for 2 or 3 years, and then dad and the new wife split up. That does not end the step-sibling relationship, just so that you know. Now, in this category, you're going to have to get very familiar with the Visa Bulletin. It comes out from the Department of State every month, around the 10th of the month, and it'll show you next month's numbers. Basically what it does, it explains for both family petitions and business petitions where people are in the line. The I-130 that you're going to file is going to fall under the F4 category. It is the slowest of the categories, and that's just because there's the most number of people trying to get in through that category. Because one of the good things about F4, which is a U.S. citizen petitioning for a brother or sister, is that when the brother or sister comes here, they're also allowed to bring their spouse and their minor children under 18. So that's all good. However, it's going to take quite a while. It's going to take quite a while to be able to get there, because, like I said, the best date right now is a 17-year wait. But what do you need? You need your birth certificate that shows who your parents are. You need your sibling's birth certificate to show who his or her parents are. If that birth certificate is not in English, you need an English translation. And you also need a certification of translation to prove that this is a valid translation. And you need proof that you're a U.S. citizen. I almost always have them send in a copy of their naturalization certificate, but a U.S. passport would do just as well. Now, if you happen to have been born here, both of my kids have brothers that live abroad because their father was from Central America. So when my eldest turned 21, I had her petition for one of the brothers. The other one, he was absolutely positive that he had no interest in coming here. The other one did want to come here. So she petitioned for him when she turned 21. She's now 31, and they still have an 8-year wait. It's ridiculous. You have to send in the check, which right now is $675 if you're going to file it with paper, and $625 if you're going to file it online. That's basically it. You're going to get a receipt back from USCIS that says they've received your money. Here's the receipt for the I-130 petition. On that receipt is going to be a date, which is, there's two dates actually. One is the date that they received the I-130, and the other is the notice date, which is when they generated this receipt. That date when they received it is your place in the waiting line. And by the way, when you get that receipt, make some copies of it. Make sure you save the original in a very safe place. If you have a safety deposit box, great. Make sure you don't lose that. You could get a new copy of it if you need to, but that's more expense and it's more time, so just don't lose it, okay? Put it in with all your important papers. So, as I mentioned earlier, there's a big, long wait for these visas. Worldwide, it's 17 years from the date that they received it, okay? And so listen, if you keep putting this off and putting this off and putting this off, and you say, well, it's been 3 months since you were naturalized, or it's been 6 months, say, I should get around to doing that. Those 6 months that you just delayed can delay the case for years. I mean, I'm not kidding, because this visa bulletin, especially in F4 category, moves very slowly. And by the way, if you're Mexican or Indian or Filipino, the wait's even longer. For Mexican siblings, 24 years. You have to wait. It's a freaking joke. It is a joke, right? Well, why don't they do it the legal way? Well, this is the legal way, and you have to wait 24 years if your sibling is Mexican. And they do it by the place of birth, where your sibling was born. Not where you were born, where the sibling was born. Not if the sibling was born in one country and then moved to another country and got citizenship in another country. Generally speaking, it's the country where they were born. You can sometimes do it by the place of birth of his or her spouse, but that's getting too much into the weeds. And you don't have to worry about it because you have 17 years to figure it out. And just so that you know, unless there's like an amazing thing that's happened with your sibling's case, there's no adjustment of status. If they're here in this country, that's a problem because there's no adjustment of status. There is an exception to that called 245I, but generally speaking, there's not an exception to that. So for most people, that's all you really need to know. Get that I-130 in ASAP. Whether or not the kid wants to come here or has permission to come here or whatever, it's going to cost you a couple $100 to secure a place for your sibling. However, for you folks who have already filed that I-130 and filed it many years ago, and now it's, the priority date is getting reached, again, the priority date is the date when you, strike that, it's the date when immigration received the I-130. Not when you filed it, when they said they received it. And that's also the date that you're going to be looking on the visa bulletin to find out when exactly there's a visa available for you. So let's say it looks like there's going to be like another 2-3 weeks until your priority date is reached. As I mentioned earlier, those 2 or 3 weeks can spread out to 2 or 3 months or more. Generally speaking, the visa bulletin really slows down in the summer because the numbers start getting used up. you can expect a jump in numbers, generally September, October, November, around there. But anyway, let's say it looks like there's going to be a visa available for your sibling, and let's say it's a her and her husband and their kids. That's great. Keep watching that visa bulletin every month as it comes out. Once your number has been reached, the National Visa Center, which is under the Department of State, not under the Department of Homeland Security, it's not connected to USCIS, but USCIS has sent a copy of the approved I-130 to the National Visa Center. So they know about your priority date. They send you a notice that actually comes in snail mail, and they also send you a notice that comes to your email. The problem with that is that how many of us still have the same email that we had 20 years ago? You can notify immigration and let them know that your information has changed, that you have moved. It's very important that you do that. Anytime you change things, make sure you let the government know so that at least your notification from the Department of State's going to show up, okay? So then what happens? Now what do you have to do? Well, of course, because it's the government, the first thing they want is for you to send them money. Send us money. They have two different fees. One is for the affidavit of support, and one is for the immigrant visa. I'm not even going to go into how much they are because this all changes. It can change from year to year. I could just imagine in 2-3 years. I mean, there's supposedly a reason why they change it, and it's all done figuring out how much money has come in and how much money was needed to provide all these services, and so then they divide that by the new people and blah, 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 blah. Suffice it to say, I can't tell you sitting here today in June of 2025 how much those fees are going to be in October of 2025. But believe me, they'll let you know. You have to pay them first. Before they'll let you do anything else, you have to pay them. Now listen, you have a year to pay it. Do not let it go past a year, because if you don't do any kind of reply to the National Visa Center for 1 year, they can very well, they're certainly within their rights, and they do it a lot, they're going to declare that that I-130 petition has been abandoned. Normally, they'll send you a notice ahead of time and say, you've got, what happens, you've got 1 more year to let us know. But generally speaking, they're going to, especially with this administration, they're going to say this has been abandoned. You've waited all these years, and because you didn't follow up on stuff, you weren't paying attention to things, and it just that 1 year went by without you paying for anything and without you then filling out the forms and providing the other documentation that you need, all that wait has been for nothing. Okay, so having said that, so you've paid your fees, and they will also give you online a list of things that you need to provide. The only thing that the petitioner really has to supply is an I-864. That's an affidavit of support. He has to show that he has enough income to make sure that you and your family are above the 125% of the federal poverty guidelines. If you don't make enough money for that, you're going to have to get a joint sponsor. That's for a different video. But the petitioner has to submit the I-864, duly filled out, signed appropriately. You're going to have to send in copies of your tax transcripts. I'm not talking about the 1040s, that you've made copies of your taxes that you filed for the last however many years. They don't want to see them because anybody can falsify them. You can go up online and get a 1040 from last year, 2 years ago, 3 years ago, and fill it out and act like Well, that's what I filed. Now, they want to see what you actually filed, what the IRS received. So you have to go up on irs.gov, make an account, get into your account, and ask for a tax transcript. Okay? And you're supposed to send in the last 3 years if you can. Maybe you can't. Maybe you missed a year. If you missed a year, they're going to want to know why. So anyway, so you have to send in your tax transcripts. You're also going to have to send in proof that you're currently employed. Generally, that's 3 months or 6 months worth of check stubs. You can also get a letter from your employer, which is written on company letterhead. It's dated, it's signed, and it says what your job title is, that you work full time, and that you make X amount of money. They either want to know what your annual is, or let's say you work 40 hours a week and you make $12 an hour. They want to be able to figure out how much money you make. So there's lots of different ways to do that. What your monthly wage is, and that it's not a seasonal job, it's a full-time job. But there's all these instructions for this. You can read the I-64 instructions, they'll help you out. So that's all the petitioner has to do. The beneficiary, on the other hand, has a lot more to do. First of all, they have to fill out the DS-260, that's the immigrant visa application. They have to upload the birth certificates, current passports. They're probably, if you're doing a sibling I-130, they already have your birth certificates, but they're probably going to ask for them again. They're going to want to see marriage certificates. Maybe the sibling got married. Oh, the birth certificates could be for minor children that have been born to the marriage since this was first filed. Some countries require police clearances. Normally you need to have a police clearance from any country where you lived for more than 6 months. So you have to check and double check that. Each country's a little bit different, and they'll give you specific instructions as to who needs a police clearance and where they have to be from, and what type of agency in each country can do that. The next thing that's going to happen, I forgot something, they're going to want you to get a medical exam. And that's not just the sibling, that's the sibling, the spouse, and all of the kids. Anybody who's coming needs to have a medical exam. And there will be instructions online about the correct person to go to. You can't just go to your regular doctor. The sibling has to go to a specific place. And it's my understanding that the civil surgeon who performs those medical exams sends the results directly to the consulate. So that you have to double check that too, because I'm sure that depends on what country you're in, what city this is being done in. So what's the next thing? You've sent in the I-64. Your sibling has sent in all the documentation that they need. They've got their medicals done. Now what? Guess what? Now there's an interview. And generally speaking, in my experience, these go through fairly easily. However, there could be some problems. One of the things they're going to be very interested in is if your sibling or your sibling's spouse, or even the kids at this point, have ever been to the United States. They're going to be looking for some kind of fraud that was done when they came here. Maybe your brother was here for a number of years and worked illegally and then lied about it on the paperwork, said that he had never been here. Don't lie on this paperwork, by the way, because guess what? The consulate has access to all of your old stuff. Everything that you said when you first came here, You're applying at the Capitol to get a visa to come here, and you told him you weren't married, and you were, or you told him that you were married, but you were actually divorced. They know all of this stuff, so they're going to be looking for fraud, especially this administration. But actually, that's true of all administrations. Sometimes those consular officers are more interested in keeping you out than helping you get in. Another thing they're going to be interested in is any kind of criminal history that any one of the family members has. That's going to be very important. If you've had some kind of, if you've been convicted of some kind of a crime, or even if you've just been charged with some of a crime, and when I say you, I mean your sibling. I'm sorry. Hope I'm not confusing people. But if your sibling or your sibling spouse has been charged, or in the past have been charged with something, they want to see a certified disposition. They want to see proof. They'll know from fingerprints whether or not you've been arrested for something. You, meaning your sibling, has been arrested for something. But they won't know what happened to that. So it's the burden of the person who's requesting a visa to prove, oh, well, that was dismissed. If it was dismissed, great. But I've had many, many clients tell me that something was dismissed when really they mean, well, that's all over with. I, did my 4 weekends for 6 weeks and I paid my little fine and everything's fine. That's not dismissed. That means that you were convicted and you served your sentence. So, anyway. Oh, and by the way, just because it didn't happen in the U.S. or it didn't happen in your home country doesn't mean that it doesn't count. Okay? Like I said previously, maybe someone in the family, might even be one of the teenage kids, went and lived in another country and got arrested for something. Got arrested for a DUI, got arrested for shoplifting, got arrested for... You need to get those certified dispositions. If it's not in English or in the language of the country where you're having your interview, you have to have it translated into English with a certification of translation. So they're going to be looking for certain things. Normally, in my experience, this is for a sibling who he and his wife have been living in their home country for many, many years. And, there's no problem. They don't have any criminal issues. None of them has been to the United States and overstayed a visa or worked without permission. It's all very clean. Takes forever when they finally get here, but eventually they get here. So different consulates do things differently. Sometimes you have to come back to pick up your passport. Sometimes they'll mail the passport to you. But whatever it is, you'll get a passport that's got a visa in it, an immigrant visa in it. And you can use that to enter the United States. You have 6 months from the time that visa was issued to use it. Make sure your sibling does not delay in getting over here. They're not considered permanent residents until they have entered the United States. They can come in, stay for a day or two, and go back, but you're not a permanent resident. Just because you got this beautiful little visa in your passport doesn't mean you're a permanent resident. You're not a permanent resident until you have made an entry into the United States, which will also generate the creation of your green card. Many, many moons ago, I had a client, Mexican guy. He was in deport. I was able to save his butt. This is way back, and we were able to do a labor cert for him. And he goes back with his wife and his six children. He goes back to Mexico. Everything's great. They file everything, and they get their visas. Every single one of them gets the visa, and they're making plans to come back to the United States. And the eldest, who's only like 19, without discussing it with anybody, decides to marry his girlfriend. You know, he's missed her so much. And he marries his girlfriend. Which, guess what? He no longer qualifies for this immigrant visa. Now, that was based on a labor search, so we're not talking a 15-year wait. But nevertheless, all those years they had waited, I don't know, 3 years, 4 years, all those years they had waited, and the kid goes home and decides, well, now that I'm a permanent resident, I can petition for her, and she can come with us too. No, genius. No, she cannot. Not only can she not do that, you can't come either. What the freak, you know? So what would have to happen? What would have to happen, right? The father would have to, 5 years later, become a U.S. citizen. And I don't think he spoke English all that great. He'd have to wait 5 years to become a U.S. citizen and then petition for his married adult son from Mexico, no less. And then wait God knows how many years for that to happen. I mean, talk about screwing up things. So please keep it in mind. You're not a permanent resident until you've made that entry. You have to have made that entry. Then you'll get your green card in the mail, you get your social security number, everything's hunky-dory, and your sibling will be good to go. Of course, that's probably 20 years from now. And the whole system could be changed by then. Although I have to admit, I've been saying that for as long as I can remember. You know, I've been an attorney in immigration, doing specifically immigration, since 92. I've been saying it since at least 2001. So we're looking at 24 years that, you know, I don't know, I can't really say because things might change. So things could change, guess what? Nothing's flipping changed. See, I caught myself there. Getting better. Nothing's changed. So this might be very good. This might be great advice 24 years from now. But anyway, the best advice I could say if you've just become a naturalized citizen, file for your siblings. Because one more thing I'm just going to tell you is that sometimes, now listen, we haven't had serious reform in decades. But in the past, when they've done things like this, oftentimes they'll look at if you've actually filed something for somebody. To make someone qualified for X, they must have done A, B, or C previously. So my advice that I give all the time is often disregarded. Whatever you can do, and do it as soon as you can. Because let's say they do change the laws, but he's got an I-130 pending. He's going to get some extra points for that. He should. Normally they would. I'm just saying. Whatever you can do it as quickly as you can. That's most of the problems that my clients have had isn't that they did something wrong. It's that they didn't do what they were supposed to do when they could have done it. Don't fall into that trap. See you next time.